Hi, my name is Jo-Anna Nieves. I am the owner of the Nieves Law Firm in Oakland, California, where we take the criminal out of criminal defense. Today, I'm going to talk to you about restraining orders. There are four major types of restraining orders in California: civil harassment restraining orders, domestic violence restraining orders, workplace violence restraining orders, and elder abuse or dependent adult restraining orders. The major difference between these is really the length of time, the burden of proof, and the parties involved. So in order to bring a civil harassment restraining order, you don't really have an intimate relationship with the other party. This is usually for neighbors, roommates, friends, strangers, people who are maybe work together, co-workers. You won't have a civil harassment restraining order if somebody has shared an intimate relationship or has close blood relations. That would be for a domestic violence restraining order. So brother and sister, and maybe a old boyfriend and girlfriend, or ex-partners, husband and wife, ex-spouses, that kind of intimate relationship. The other type of restraining order, elder abuse, is for people who are age 65 or older, or they're dependent adults, so they are in need of care and they have a caretaker who is able to file on their behalf by way of some sort of power of attorney or conservatorship or whatever other legal authority they have that gives them standing to file the petition. And finally, workplace violence is brought by employers on behalf of employees who need protection. So this can only be filed by an employer if there is some sort of credible threat of violence against that an employee or multiple employees and that endangers people at the workplace. Workplace violence restraining orders can be granted for a maximum of 3 years. Elder abuse, domestic violence, and civil harassment can all be granted for a maximum of 5 years. In addition to those differences, the burden of proof changes. So for civil harassment and workplace violence, the burden of proof is clear and convincing evidence. This is the second highest burden that is there. So in criminal cases, the burden of proof is beyond a reasonable doubt. In civil harassment cases or in workplace violence cases, it's clear and convincing evidence. So you need something that is going to be persuasive and compelling and supported by some type of evidence. On the other hand, elder abuse and domestic violence cases are what would be considered preponderance of the evidence, that the judge is able to say it's more likely than not that this occurred. There's no real percentages assigned to things, but oftentimes people describe preponderance as like 51%, and clear and convincing is kind of up in those high 75-80%, and then beyond a reasonable doubt is in the 90% range. These are not real percentages, but that's just to give you an idea of like the stepping up of the burdens of proof. And so it's more difficult to prove a civil harassment restraining order or workplace violence restraining order than it is to prove elder abuse or domestic violence. If you have a question about a restraining order or the burden of proof, or whether or not you should file EA, DV, CH, or workplace violence restraining orders, or you need defense of one of these type of matters, please call our firm. We have experience doing all of these on both sides and have had much success in the area. Thank you.